everyone. My name is Lisa Soronen. I'm the Executive Director of the State and Local Legal Center. I'm excited to be here today to talk to you about what happened in the Supreme Court last term and how it relates to pools. I'm going to spend a lot of my time in this presentation on the First Amendment because the court spent a lot of its time on that amendment last term. I'm also going to talk about guns and about a number of issues related to police officers. So the biggest thing that happened to pool members last Supreme Court term was the Supreme Court overruled the Lemon test from 1971 and replaced it with a new test. The Lemon test applied to the establishment of religion cases, and importantly, Supreme Court justices said in 2 cases that local governments lost cases before the Supreme Court because they were relying on Lemon when they shouldn't have been. So many of you may not think about Lemon all the time. Some of you have maybe never thought about Lemon. But Lemon, like I said, was an Establishment Clause test that had a number of prongs. And basically, the bottom line with Lemon was governments had to ask themselves, were they getting too involved in religion? Some involvement with religion was okay, but not too much involvement. So it was kind of a mushy test. And the court hadn't applied it in a really long time, but it remained on the books until this term. So the case in which the Supreme Court overturned the Lemon test is Kennedy versus Bremerton School District. It was a 60th opinion written by Justice Gorsuch. The holding of the case was that the First Amendment protects an assistant football coach who knelt at midfield after games to offer a quiet prayer of thanks. What's very unusual about this case is that the justices in the majority and dissent very much disagree about what happened in the case. I'll tell you what happened that they both basically agree on. So Joseph Kennedy was an assistant football coach. He had a long history of praying with students in the locker room before and after games and at the 50-yard line. Initially at the 50-yard line, he prayed alone, but eventually some students started joining him. The school district found out about this prayer practice in an interesting way. A coach from another team went up to the principal and said, gee, it's nice that you allow your coach to pray with students. The principal and the superintendent promptly told Coach Kennedy to stop praying at the 50-yard line and stop praying in the locker room before and after games. He agreed to stop praying in the locker room. But he said he was going to continue praying at the 50-yard line, and it was a free country, and so students could join them if they wanted to. The district ultimately non-renewed his contract and put him on leave. But importantly, for at least some of the justices, for the games that he was actually let go, no students joined him. But in other games, students had joined him and students were still welcome to join him after games at the 50-yard and pray. So the district said it suspended Kennedy because of Establishment Clause concerns. It was worried that a reasonable observer would see his prayer and think that the school district was endorsing religion. In response, the Supreme Court overturned the Lemon test. So here's the new test. The court adopted a view of the Establishment Clause that accords with history and faithfully reflects the understanding of the Founding Fathers. In other words, government can be involved with religion as long as it accords with history and faithfully reflects the understanding of the Founding Fathers. Now, there's a lot of challenges to doing a historical analysis. For example, what historical sources have to be considered? What if the Founding Fathers disagreed? What if the Founding Fathers didn't contemplate an issue? And what if modern life is significantly out of step with what the Founding Fathers thought? Well, the court doesn't go into any details on that, so only time will tell. When it comes to the Establishment Clause, the details are fuzzy, but the general trend is clear. The Supreme Court is taking a narrower view of the Establishment Clause. This means that governments can and maybe must be more involved with religion without, in fact, establishing religion. If you want to summarize what's going on with the court, probably these 3 words are the most appropriate: more religious liberty. We have a Supreme Court that is interested in more religious liberty. So now the big question for pools: what to do? So employees of all pool members, including elected officials and attorneys representing the pool members, must be informed of this decision. think it's really important that frontline employees in particular are informed of this decision and are told that if an establishment clause issue comes up, that they should seek the assistance of their lawyer to do a historical analysis. The reason why I highlight frontline employees is, remember who this issue first went to. It was a school principal. And most principals have one school law class as part of their education where they don't become First Amendment scholars. I hate to be the bearer of bad news, but even if pools and their members do the very best they can, lawsuits in this space should be expected. The court's test is new. It's likely going to be hard to apply, and it doesn't lead to any clear answer on its face. And equally importantly, lower courts haven't had a chance yet to apply it. The City of Boston case has a number of faces. It's a government speech versus public forum case. It's a third-party flag case, and importantly, it's a religion case as well. The City of Boston flew 3 flags on flagpoles near City Hall. The first flag flew the United States flag, the second flag, the Commonwealth of Massachusetts, and the third flag flew the City of Boston's flag most of the time. But sometimes the city would have events, usually for particular nationalities. I like to use Lithuanians as an example because it's fun to say Lithuania. So the Lithuanians in Boston would gather at City Hall, they would fly the Lithuanian flag, and they would celebrate their heritage. But other flags were flown as well. The gay pride flag was flown. For some reason, a community bank flag was flown. So you all know what happens next, right? Because this is a religion case. So Camp Constitution showed up and said, we want to fly our flag, our Christian flag. And Mr. Rooney, who was the commissioner of the city's property management department, who sounds like a high-ranking person, but probably not someone with legal training, said no. He was concerned about establishment clause concerns. He was concerned that members of the community would perceive the city as endorsing religion. So like I said, this is this dispute is ultimately between government speech and the forum doctrine. So if what was going on here was a public forum, there can be no viewpoint discrimination. And of course, excluding a flag based on religion would be viewpoint discrimination. But if this was government speech, then the First Amendment doesn't apply and the city could fly any flag it wanted and deny any flag it wanted. I love what Justice Breyer said about this case. The boundary between government speech and private expression can blur when, as here, a government invites people to participate in a program. So the court ultimately concluded that this was a forum and not government speech. It said, there were factors that made this look like government speech. For example, historically, cities fly flags as a means of government speech. But Justice Breyer pointed out it might have been confusing to people to see that sometimes the Boston flag wasn't flown, it was another flag. But ultimately, what the court said was this: Boston did not have a written policy that explained that its third-party flag program was in fact government speech. And when it flew those flags, it was essentially speaking itself. And that's ultimately why the court said that this was a public forum and not government speech. So if pool members have third-party flag programs, they should look at this case and modify their flag programs as is appropriate. Now, most pool members probably don't have third-party flag programs. They're not actually all that common. But here's the deal. This is really a government speech case as much as it's a third-party flag case or a religion case. And it's oftentimes that it would be a frontline employee, like in this case, who's making a decision and needs to know whether something is a public forum or government speech. Now, governments want speech to be government speech as often as they can because the First Amendment doesn't apply. And in all the cases I can think of before the Supreme Court that have recently considered the government speech doctrine, there's been some involvement with third parties. So this case has implications well beyond just the narrow context of third-party flag programs. The City of Austin case is a free speech case rather than a religion case. The Supreme Court held that local governments may have different rules for on-premise and off-premise signs as long as these rules are narrowly tailored to serve a significant government interest. This case is really a different rules for billboard case. this case is a huge win for local governments for two reasons. First, it is very, very common for local governments to have different rules for on-premise and off-premise signs. And if the court said that strict scrutiny applied, it would be much more difficult to have those rules. And in fact, most local governments would have had to change their rules. The other thing is, as I just alluded to, the court could have held that strict so-called fatal scrutiny applies to these distinctions, which basically means they couldn't be made anymore. So what pools need to do as a result of this decision is they should tell their members about this great win. It's most important for local elected officials to know about this and planners to the extent that pool members have planners. But it's also important to remind members this: you can't automatically have different rules for billboards and for on-premises signs. To do this, local governments have to cite to a significant, narrowly tailored reason for treating on-premise and off-premise signs differently. Now, the reasons that are typically given are traffic safety and aesthetics. And in fact, Justice Breyer, in his concurring opinion in this case, talked about the fact that traffic safety is very relevant to not having digitized billboards. As this quote illustrates, there is a lot of information on a state basis, maybe even on a local basis, that explains how traffic safety can be affected by billboards, especially distracting ones like digitized billboards. Houston Community College versus Wilson is the last First Amendment case I'm going to talk about. This is also a free speech case. The court held that a board censure of a board member does not violate the First Amendment. The decision in this case was unanimous, and it was very, very narrow. What pools need to do is tell their members about this decision. Obviously, it's most important for elected officials to know about this because this case affects them directly. But this is the message to convey. This case could not have been narrower. And in fact, the court's opinion arguably raises more questions than it answers. On this slide, as I describe, the court explicitly said, we're not going to decide whether anything other than a verbal censure violates the First Amendment. In fact, in oral argument, the court talked at length about whether or not jailing a board member would violate the First Amendment. Now, they did not decide that question, nor did they decide any of the questions on this slide. They just simply decided that a verbal censure of a board member doesn't violate the First Amendment. Last term, the Supreme Court decided the second gun case ever. And it has big implications for states and local governments as well. Technically, what the court held in this case is that states and local governments may not require proper cause for someone to obtain a license to carry a gun outside the house. I don't know whether any local governments in this country required people to show proper cause to have a concealed carry permit, but I can say that 25% of the US population was under a state law that required this, largely because these laws existed in California and in New York. So the test that the court applied to overturn New York's requirement for proper cause to get a concealed carry permit was one involving text and history. So basically, what the court reasoned was that historically, people didn't need to show proper cause to receive a concealed carry permit, so they shouldn't be required to show proper cause today. Now, this is the important point for local government. The test that the court did not apply is one that considered local government and state government interests. For the last 15 years, lower courts have been deciding all kinds of gun cases, regulating guns in all kinds of ways. Largely, lower courts have upheld those gun regulations, relying on the fact that governments have an interest in regulating guns. This is no longer part of the test and will not be part of the test going forward, at least in theory. I put this slide in red for a reason. So Justice Kavanaugh and Justice Roberts wrote a concurring decision. And they said, you know, a lot of traditional gun laws, like ones that prevent felons from having guns, the mentally ill from having guns, ones that disallow guns in sensitive places, ones that regulate the commercial sale of firearms, one that regulate dangerous and unusual weapons. Those laws should not be struck down as unconstitutional. Those laws should remain on the books. The reason why that language is such a big deal and why I put it in red is that on one hand, that language comes from the first and most important gun case of all time, which was decided about 15 years ago. But here's what experts say. They say that New York's concealed carry permit had a longer standing historical pedigree than many of the requirements that Justice Kavanaugh and Justice Roberts wrote about in their opinions. So historically, for example, apparently governments didn't prevent people who are mentally ill from having guns. So the question that the lower courts are going to face is, which do we apply? Do we apply that historical test that Justice Thomas wrote about, or do we look to the concurrence that Justice Roberts and Justice Kavanaugh wrote that said, we think these things are kind of automatically okay. So only time will tell, but I can say this. A lot of local governments have a variety of gun regulations. And in theory, the test that needs to be applied to those gun regulations was, historically, were those gun regulations okay? I think what's going to happen as a result of this decision is that any gun regulation now might be challenged. And the reason is because we have now an explicit test, if not a totally clear test. And we have a court that's willing to decide gun cases. So I think what pools need to do is they need to tell their members about this decision. It's most important that local elected officials know about it because they're the ones who have the authority to regulate guns. I also think it's important to highlight this, that not all gun regulation is going to be overturned by the US Supreme Court or by lower courts. But at this point, we don't really know what gun regulation is going to be overturned. So time will tell on this one. So talking about qualified immunity from the perspective of a timeline, I think makes sense. In October of 2019, the Supreme Court started receiving a bunch of petitions that asked them to eliminate or modify the doctrine. And rather than just dismissing those petitions, they held on to them for months. In June of 2020, the Supreme Court dismissed all the petitions without explaining why, which is pretty typical. 2 terms ago, the Supreme Court reversed a grant of qualified immunity to a number of jail employees, and in 2 other cases, instructed the lower courts to redecide 2 cases where the lower courts had granted police officers qualified immunity. Now this term, the Supreme Court reversed 2 lower court cases where the lower court found excessive force and denied the police officers qualified immunity. So you might be wondering, what is the Supreme Court thinking about qualified immunity? Holding on to those petitions that asked the court to eliminate or modify the doctrine and reversing the grants of qualified immunity 2 terms ago made a lot of people nervous, including yours truly. However, the qualified immunity decisions from this term have done a lot to relieve my anxiety and worry over qualified immunity. So I'm going to discuss those cases in a little bit of detail. The first case involved a young girl calling the police and saying, my mom and my sister and I are trapped in a room in our house. My mom's boyfriend has a chainsaw. Police arrived on the scene and got the guy to come out. But they noticed he had a knife in his pocket. So they asked him to put his hands up, and instead he put his hands down. So they shot him with a beanbag, and eventually he put his hands up and he got on the ground as they requested. An officer came over to him and knelt on his back for about 8 seconds and raised his arms. Another officer came over and then pulled that knife out of his pocket. Like I said, I'm going to emphasize this. The entire knee on the back incident lasted about 8 seconds. The Ninth Circuit said this was excessive force and denied the officer qualified immunity. And it looked at a case called Lalonde. Lalonde involved a noise violation. It did not involve an individual who is armed in any way. In that case, the officer purposely jammed his knee into Lalonde's back for a lengthy period of time. The Supreme Court said there is no analogy between this 8 seconds done gently to release a weapon, and throwing someone on the ground, jabbing your knee into them, related to a noise violation. So the court reversed the excessive force and granted the officers qualified immunity. The Bond case involved a man who, for whatever reason, kept his tools at his ex-wife's house in the garage. He was drunk and he wouldn't leave, so his ex-wife called the police. The police showed up and they had a rather lengthy conversation with him where they basically just tried to convince him that they could give him a ride home. He ultimately grabbed a hammer, and what he did was he held it up like he was going to swing a baseball bat like this. He pulled it up to shoulder level. So of course they screamed, put it down, and he didn't. Then what he did was he got out from behind some furniture and he raised his arms like he was going to throw it like an axe. And they ultimately shot and killed him. So again, the 10th Circuit here said this was excessive force and denied the police officers qualified immunity. The cases they claim, the 10th Circuit claimed that established that this was excessive force involved individuals who were in cars where people called 911 and said, so-and-so is in a car at this location, they have a gun and they're going to commit suicide. So what police have done, for whatever reason that isn't totally clear to me in this circumstances, is they have often rushed these cars, screamed at the person, pulled them out of the car, and pulled the gun out. And courts have said that's excessive force in that situation. And the Supreme Court said there's no analogy here between, sort of almost attacking someone in a car who has a gun, who's thinking they're going to commit suicide, and someone who's heading towards an officer holding a hammer in a manner that looks like they're going to throw it like an axe. So again, the court said no excessive force and granted the officers qualified immunity. In my opinion, these were not close cases. In my opinion, unequivocally and absolutely, the lower courts just got these decisions wrong. And so I don't think these cases move the qualified immunity doctrine anywhere. I don't think they give us any real insight into the doctrine. So what I think that pools can do is tell their members, police officers and elected officials in particular, that they can exhale for a while on qualified immunity, but that they should keep their eyes on the doctrine. So something very interesting came out of this case. Joanna Schwartz, who is an amazing scholar who writes basically critical articles on qualified immunity, citing to policy reasons, who on some level is sort of my nemesis, but like I really kind of admire her because her work is so good. She wrote an article in USA Today, and she basically said, when it comes to qualified immunity, the Supreme Court holds officers to know and understand circuit court precedent. And if circuit court precedent doesn't clearly establish something, well, then the officer gets qualified immunity. But her argument is this, that local police officers are in fact not trained on circuit court precedent. They may know the big Supreme Court cases, but they don't know anything about circuit court precedent, so she says. I am skeptical about whether or not this is true. What she claimed as her source was she looked at education materials review in California. Well, what education materials, and why not more states? And so all this to say this, she makes a good point, which is simply that local police officers must be trained on circuit court precedent. And if that's not happening, it's putting pool members at a legal risk. So as I wrap up, I'm going to talk about two more police cases decided by the Supreme Court last term. The first one involved failure to read Miranda, and the second involved requirements to bring a malicious prosecution claim against police officers. So in Vega versus Tejo, the Supreme Court held that police officers can't be sued for money damages for failing to provide a Miranda warning. This was a big win for elected officials and police officers, which pool members should be informed about. The reason why this case is such a big win is this. Police officers must constantly decide, really in every interaction with a citizen, whether or not they need to recite Miranda. The criteria is whether or not a person is in custody, and that is not necessarily totally clear. One good reminder from this case, though, is that even if police officers can't be sued for simply failing to recite Miranda, if they engage in coercive investigative techniques, they can be sued for money damages, regardless of whether they recite Miranda. So many of you may wonder what a malicious prosecution claim is. I have to confess that before I worked on this case, I too wondered that myself. Malicious prosecution claims are brought against police officers when someone is arrested and charged with a crime who thinks he or she should not have been arrested or charged with that crime. To sue a police officer for malicious prosecution, the prosecution must have, and I quote, been terminated in the acquittal or discharge of the accused. In Thompson versus Clark, the Supreme Court held that to bring a malicious prosecution claim against a police officer, a plaintiff need only show that the prosecution ended without a conviction. So what the person doesn't need to show is that it ended with some affirmative indication of innocence, which is what the Second Circuit had held. So this case is considered a loss for pool members. So what pools need to do is inform their members, most importantly elected officials and police, that the Supreme Court has essentially made it easier to bring malicious prosecution claims because all you have to show is that you weren't convicted. You don't have to show that you were probably innocent. And then these claims can be brought against a police officer. So this case involved New York City. It's very common for big cities to have a number of these claims, in part because they just have a lot of police officers. But this type of a malicious prosecution claim can arise anywhere.